Well, welcome everybody, and thank you so much for coming. My name's Therese Wilson. I'm the Dean of Law and Head of School at Griffith Law School. I'd like to start by acknowledging the traditional owners of the land on which we meet and pay my respects to their elders, past, present and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people with us this evening. It's my very great pleasure to introduce our guest speaker, who's visiting us from Queen Mary University, although I think via Singapore, where he is also...
I'm yet to get to Singapore.
Yet to get to Singapore, about to go and visit in Singapore. So Christian Witting is a Professor of Private Law at Queen Mary University of London and to be a visiting Professor at the National University of Singapore. He's also a barrister and solicitor of the High Court of Australia, so you'll detect the Australian accent. He's one of ours, even though he's so international and well-travelled. Formerly in service with the Commonwealth Attorney General's Department. And he has research interests in both company law and tort law, which makes him eminently qualified and suitable to present the paper that he's presenting to us this evening, which is on Organisational Vicarious Liability. So if you could join me in welcoming Professor Christian Witting.
Thank you very, very much, and I must thank Griffith Law School for a fantastic week so far. I've been treated so nicely, and it's such a great place to be, so I'm really grateful that you've hosted me, and thank you very much, Justice Applegarth, for the tour earlier on today, which was a privilege. So I am going to talk about vicarious liability, and I should start with a kind of warning, which is that this is my third or fourth attempt at finding an explanation to vicarious liability. Perhaps if I had known what was ahead of me 5 years ago or so when I started this project, I might have thought twice, because you might think when thinking of the elements of vicarious liability that this cannot be an impossibly difficult doctrine to explain, but it certainly has been. By the way, I have been doing some other things over 5 years. It's not just been this. Okay, so perhaps I can start by pressing the right button there. Perhaps I can start with the idea that judges often express, which is that vicarious liability, along with tort law rules in general, are there to compensate, and we'll get to this a bit later, also to deter. I don't think anybody can really quibble with the idea that vicarious liability does indeed help to compensate victims of torts. But compensation can't be the sole explanation of vicarious liability. It, for instance, doesn't explain why it is that vicarious liability only applies with respect to, in this country at least, employment relationships. When we move to the UK, where you might know the law has been so-called on the move, explaining vicarious liability has become more and more difficult with successive developments. So just to briefly run through those developments, we've moved away from a relatively rigorous course of employment test to one which looks to see whether there is a sufficient connection between the relationship and the commission of the tort. We now have the idea that it's not only employees for which the employer might be responsible, but also for those who are in relationships akin to employment. And of course that's always been a bit of a fudge. What exactly does that mean when there is no contract of employment? We've also had more recent innovations where, for instance, the Nottinghamshire County Council has been made responsible for intentional acts of abuse committed by foster carers, so at quite a remove from council premises, in fact in private homes. And very recently, the last month, I think in the Barclays case, we've had what is, I think, a frank recognition that we've now moved on from the position where vicarious liability is imposed simply with respect to employees. It can now extend to independent contractors, and that seems to be a real breach of a former limitation. Now, a lot of these developments have come in cases where obviously there's been a lot of deep felt concern for victims and the desire for compensation to be paid. But that doesn't necessarily mean that the developments which have taken place have been appropriate, and there are many commentators who think that the law in the United Kingdom has now become a bit of a mush, that there are no inherent limits to the law of vicarious liability, that we're really proceeding from case to case. And I think this is the latest comment from the High Court of Australia in the Prince Alfred College case. The High Court of Australia certainly was not on board with developments with respect to the sufficient connection test. Such a test of vicarious liability requiring no more than sufficiency of connection, unconstrained by the outer limits of the course or scope of employment, is likely to result in the imposition of vicarious liability for wrongful acts for which employment provides no more than an opportunity. It becomes really just an excuse for imposition of liability. So I'm sure that they would have a very dim view of the more recent developments. And indeed, I was horrified initially with many of these developments. I think that if you've got a very well-settled rule, or in this case a well-settled doctrine, there must be good reason for it, and you shouldn't go messing with the rules simply to achieve justice in the individual case. There can be other mechanisms for compensating. Okay, so there we go. I think that the compensation rationale itself does fall short. It's part of the story of vicarious liability, but the question is whether there is any further explanation for it. In terms of current justifications, I think that it's probably well understood that enterprise liability is the most comprehensive and probably most cited other justification. So there's compensation and enterprise liability. And as I've discovered in my researches, in fact, the germ of this idea really goes back a long, long way. So the courts have been quite consistent in pointing to essential elements of what we now call enterprise liability, and this is just one of the earliest cases. Chief Justice Best in Hall and Smith said that the maximum of respondeat superior is bottomed on this principle, that he who expects to derive advantage from an act which is done by another for him must answer for any injury which a third person may sustain from it. Just to fill out the idea a little, perhaps referring to some academic commentary on this, what we're talking about is a type of liability which is imposed upon what we call the enterprise. We're usually talking about business organisations or other organisations, arising from inherent risks in the business operations which are expected to yield some sort of benefit for the organisation. In the circumstances, it's seen as fair to impose a responsibility. It's kind of a quid pro quo when injuries arise. So that's a kind of a fuller statement of what we mean by enterprise liability, and we can see aspects of enterprise liability in some of the more recent UK Supreme Court decisions. So I think, again, this is what the courts believes to be a reasonable explanation. However, the courts in the UK probably are running a little bit ahead of the theory now in a number of ways. For instance, if they've decided that any benefit that we might talk about need not be simply financial in nature. It could be anything valued by the defendant organisation, which once again creates a degree of vagueness in this doctrine. In fact, I would say that recent cases really don't sit well with the idea of enterprise liability here, especially the assertion that vicarious liability encompasses businesses, and the courts are calling them businesses that in fact don't operate under ordinary profit incentives. And I've just given you the example of the Nottinghamshire County Council case. It's described in business terms. It's operating some sort of business, even if it doesn't involve earning profit. I think that this is problematic, and in fact it's not just me. Quite a number of commentators, and also, for instance, Lord Justice Tomlinson in the E case have discerned a problem here, and that is that well, with a for-profit business, it's those who own the business and running the business who themselves earn some kind of surplus. But with non-profits and with government departments and public authorities, any benefits are really not for the government or the operators. The benefits are for third parties. So to me, that means that the kind of exploitative quality that you might find in the operation of a for-profit company or other business, you probably won't find in the misdeeds of the non-profits. So I think that enterprise liability is really starting to lose its cogency as an explanation for the current rules of vicarious liability in the United Kingdom. That is not to say that they do not have a greater cogency in this jurisdiction. However, I think that the writing on enterprise liability has been an important step in looking to a more defensible theory about vicarious liability, because, for instance, it takes into account the fact that the defendants in these cases today often are organisations, larger enterprises with assets or with insurance available to cover tort judgments. And of course, many of the defendants in fact are profit-making enterprises, and I think that we are reasonably content with that quid pro quo of liability for injury. But the thing is that enterprise liability is really no longer a very comprehensive explanation of the doctrine. So the question is, where do we go from here? Well, there have been a number of indications in the literature of where we might go. Writers who have indicated that the future might be a theory which is more focused upon the idea of organisation. So far as I can tell, one of the best indications of what the future holds was an article by Christopher Stone, who's at the University of Southern California, written in 1980, where I'll just read through this. He adverted to internal features of large business organisations as bureaucracies characterised by information flows, managerial control, and the ability to plan for the future. in an increasingly organisational bureaucratic world, wrongdoing could be attributed often to flaws in the organisation's formal and informal authority structure or in its information pathways. So he thought that vicarious liability might be important in helping to impose direct and selective constraints on how managers work out various internal relationships. I started thinking through a theory with many of these elements before I came across Christopher Stone's article, but I think it's illuminating, and I would have to say then that I'm trying to take up this idea and perhaps to develop a little bit more. Okay, so that's what I'm intending to talk about, but I have to make a digression before we get there, because I think that in fact, apart from the compensatory rationale, there are two different justifications that are important in explaining vicarious liability, and they are justifications that apply to different kinds of defendant. So there are what I would consider to be classical cases. I'll explain what that is in just a second, and then also the newer cases which are concerned with organisations. So what are these classical cases? So what I see is this, that the rules of vicarious liability essentially were developed in a simpler time when organised activity was undertaken by particular types of persons, small traders, craftsmen, women, and also farmers. These are the typical cases. So perhaps to put it in business terms, these were people undertaking personal capitalism, and one of the points about these sorts of defendants is that the owner-managers were in personal relationships with all those who worked for them. And most likely they were personally directing the work that was being undertaken. So to me then, it's not surprising that if you look at most of the cases on vicarious liability, and certainly any of the foundational cases, that agency is a concept which runs through them very thickly. Agency seems to be at the heart of these cases. So, for instance, if we have a look at when the modern law began, and that seems to have been at the end of the 17th century and the beginning of the 18th century with judgments of Chief Justice Holt, we can see the importance of agency. The importance of Chief Justice Holt's contribution was this, that as I explain it here, what he tried to do was to better balance the interests of the injured claimant and the defendant master by just extending the agency idea from actual or express command to implied commands, so that the defendant employer would be liable for those acts which were impliedly commanded or authorised by the defendant. Okay, so an example of this is the Tuberville and Stamp case, which is often cited, one of the foundational cases here, and this is what Chief Justice Holt said: if the defendant's servant kindled the fire in the way of husbandry and proper for his employment, though he had no express command of his master, yet his master shall be liable to an action for damage done to another by the fire, for it shall be intended that the servant had authority from his master, it being for his master's benefit. So there's clearly an important idea of agency here, and this is one of the seminal cases often quoted for this dictum. Now, if you read Dr. Batty's treatment of vicarious liability, he is extremely sceptical of this sort of case as an authority on vicarious liability, because he thinks that fire cases were different. They were going to be characterised by a sense of strict liability. We can't treat this as any general authority on vicarious liability. Now, when we talk about agency here, although it seems to be clear that Chief Justice Holt was very familiar with the commercial cases, we aren't talking about agency as it arises in commercial or contract law. We're not talking about cases of specific agreements to act for and on behalf of another. It seems to be clear that we are simply talking about cases in which the defendant, the employer, is fulfilling his or her purposes through the acts of another, and we have got Dr. Batty's imprimatur for that statement. Okay, so I'm suggesting that at least in these older cases, in these cases of personal relations between the defendant employer and the employee, that agency is a really important concept. It seems to be, along with employment, the best explanation for why liability arises. If we look at the position in the United States, this seems to be confirmed. Now, I should say, with respect to the United States laws on vicarious liability or respondeat superior, that these rules have not developed in the radical way that the UK rules have developed. The US courts have been a lot more conservative, and they have really adhered to the same sorts of traditional rules that Australian courts seem to. So it's interesting then to see where rules of vicarious liability are treated in the restatements. In the restatement third of agency. And if you read through that quote, maybe many of you have gone through it already, it's redolent with the idea of agency, and I assume that we're talking about agency in the sense of one having another conduct his or her business affairs. So, and I think all of this does make a certain amount of sense, that agency should be an important concept where you have got the owner-manager who personally appoints employees, who has got the ability to direct how those employees behaved, within a certain extent. But also, what I would see as important in this story, the capability to deter wrongdoing by doing such things as monitoring the work of the employees and so on. So that's, I think, the first part of the story. That in these cases of personal relations, agency seems to be an important explanation. But of course, in the more modern law, the defendant typically is no longer an owner-manager in that sense. The defendant typically is an organisation. And as such, I don't think it's any coincidence that the UK law has started to move away from, without completely abandoning, agency as an explanation for vicarious liability. Now, depending on how you look at things, you might say that the rot began in the Lister and Hesley Hall case, another one of these cases involving child abuse. And if you recall, that was the case in which the House of Lords had to consider the application of the Salmond test, involving the idea of an improper mode of performing an authorised act. And unsurprisingly, when things came to a head, the House of Lords was unconvinced that this was a particularly appropriate test to be applying. So we had the idea that at the second stage of vicarious liability, a sufficient connection with the employment would be enough. And of course, that involves some introduction of discretion into decision making. So CCSW from, it is actually CCWS, from 2012, I guess is another milestone along the way. Firstly, because there's an explicit recognition by Lord Phillips that most defendants are, in fact, companies, or we might say organisations. And this is important because it's at this point that, in fact, in the cases we start seeing a recognition of some of the important qualities of organisation. So the thing about the larger, medium-sized and larger organisations is that, in fact, we move away from personal capitalism. We move away, so my reading tells me, from direct relations between managers and employees, and we move into bureaucracy, okay? And bureaucracy here we can basically describe as involving several layers of management and indirect communications between top managers and lower employees. So it may become then a little bit more artificial to talk about agency in these cases. It may not. But I don't think it's really necessary to totally discard agency reasoning in these cases. But what we see is the development of a sort of a different understanding of the defendants and the defendants' capacities. So what I think I see in the case law and also the literature since, let's say, CCWS, are a number of building blocks for a new theory of vicarious liability, which explains the imposition of liability upon the organisational defendant. Okay, so now what I'm going to set out now, a number of bullet points which are kind of the evidence. So these ideas come from the cases. I haven't made them up. And I think they can be reconstructed into some kind of theory about organisational liability. So we have the idea that we're talking about organisations, and one thing that's mentioned in CCWS is that they involve hierarchical relationships between the organisation and those persons who are doing the work. We then have the idea that in hierarchical relationships, the organisation is able to exercise control over the work that is being done. So obviously by employees, but also by extension by others. Okay, and it seems to be that what's important is the exercise of managerial control. So it's controlled by management. And we have the idea that the organisation is able to take measures internally within the organisation in order to do such things as to discipline the workers and or reform the way in which the work is done. We also have an older idea about enterprise and about wrongdoers who are integral parts of the enterprise, or what we might call now the organisation. And finally, so again, this is just evidence that I'm taking from the cases and hoping to use in order to reconstruct a theory here. The idea of deterrence. Now, deterrence seems to be kind of the D word in the cases. Sometimes we are brave enough to mention deterrence, and we see it, for instance, in the Court of Appeal's decision in Gravel and Carroll, where Sir Anthony Clark said that the imposition of liability upon a rugby club for wrongs of a player was justified by deterrence of the club by bringing home the liability so as to prevent or minimise the risk of foul play in the future. But most usually, deterrence isn't mentioned by name. It seems to have assumed the status of a discredited theory in the tort law, and this seems to be understood by judges. But what else can be behind a statement such as this by Lord Justice Ward, talking about the notion of control being important in terms of whether the employee is accountable to his superior for the way he does the work so as to enable the employer to supervise and effect improvements in performance and eliminate risks of harm to others. I mean, this is a statement about what will happen after the imposition of liability. It's a forward-looking statement, and it's about improving things so that wrongs aren't committed. This seems to me exactly what deterrence is about. Okay, so these are pieces of evidence that I've taken from the cases, and so this is my thesis. It's just a thesis. Something for you to think about, although I'm taking it rather seriously in my writings after 5 years. I've got to have something to show for all of this. Okay, so my thesis is that organisations are deterrable parties, vicarious liability being a means of inducing in them development of proper standards of conduct in operations undertaken by employees and quasi-employees. Just a couple of notes about that. So firstly, I've got a very simplistic, perhaps, view of tort law and what tort law does. So this is not Alan Beaver's corrective justice or whatever. It's a very simple view, which is that tort law is about setting proper standards of conduct as between persons in their interactions, and this resolves what we might call coordination problems. And it's not just tort law that does this. I think that a lot of law is about that, about proper standards of conduct. Okay, so it's a pretty simple view, and I think that tort law has this purpose. And one of the means for achieving that is through what we might call the operation of deterrence. But I'm being a bit careful here. I'm not saying that tort law does always deter. And in fact, I think we need to distinguish between different types of defendant. I think that some defendants are more deterrable than others. I hope people aren't getting a headache by this stage. And the primary deterrable parties are organisations, for reasons which I'll explain, and also professional persons. So I admit that it is less easy to deter some other kinds of defendant. But that does not mean that deterrence does not have a role to play here. Okay, so I develop this thesis now by reference to three themes. And the first one concerns the fact that vicarious liability is a doctrine of strict liability. And I think it's important to understand, well, this is my understanding of strict liability, because it does fit in then, I think, with a deterrence sort of justification for it. Okay. So, now, in many of the cases, for instance, Lister and Hesley Hall, we get the idea that vicarious liability involves imposing liability upon defendants who are not at fault in wrongdoing. And I think that this is just really wrong. Why is it wrong? It's because in a strict liability rule or doctrine, in fact, fault is irrelevant, so there's no inquiry into fault, there's no evidence before the court as to whether fault exists at all. So this is Peter Kane's conception of strict liability, and I believe him to be correct there. Okay, so we're talking about cases in which the court doesn't look at the evidence. There is no evidence as to whether there was fault or not. Now, that means that there's every possibility that in a case of vicarious liability, the defendant, in fact, was at fault. And we see that Lord Steyn in the Bernard and Attorney General of Jamaica case understands that. And the point is, I think that intention, negligence and strict liability are not exclusive of each other. In fact, they arise on different dimensions. And the point about vicarious liability is that it's a strict liability doctrine which just doesn't involve inquiry into fault. Now, in fact, what strict liability does is to improve the position of the claimant because they don't have to prove fault. Abraham, in a 1987 article, believes that strict liability frequently is imposed where you suspect that defendants are at fault, but where you don't think that it should be necessary for the claimant to prove that. Okay, so he thinks that we can even go so far as to say that in many cases where you see strict liability, it's a proxy for fault. Now, I don't want to over-egg this, but the point simply is this, that our organisational defendants may well, in many vicarious liability cases, be at fault. Okay, so imposing vicarious liability upon them may not be a bad thing, and perhaps I'll go on to develop that idea with the second theme, which is that I think what is going on in vicarious liability is this. Too many ideas. It's really too many ideas for one night, but I have to go on. I think that what we've got going on in vicarious liability is that, again, the courts are interested in standard setting. It's just that the courts are not doing that themselves. In fact, courts are often in a bad position to set standards observed by complex organisations. But what they do is they place an onus upon the defendants here, the organisations, to essentially get their houses in order, to do what they can in order to eliminate the risks of tort occurring. So we have to think of strict liability in different terms from fault, and in my view, strict liability is this forward-looking basis of liability. It's saying that if X occurs, you will be liable for X regardless of fault. So the natural consequence of that is that if you want to avoid X, you will do what you can to take precautions. Okay, so, and I think that this is what we see going on in at least vicarious liability cases involving ideal defendant organisations, that they will do what they can in order to respond to this onus, that they will develop appropriate precautions, and I'm going to go through those in a bit more detail. And I think there's a sort of a comparison that can be drawn here with the way in which modern regulation works, and that is that the legislature doesn't necessarily set out all the relevant standards. That's not necessarily done by it's not necessarily done by the regulatory authorities. The task of setting those standards is delegated either to industry associations or to organisations. That is where the primary responsibility often lies. For instance, in financial services, where innovation just occurs so quickly that you cannot proactively legislate or create the rules. You can create principles, but you've got to leave the standard setting to either industry or the organisations. Okay, I'll do the next bit quickly because it's probably far too boring, but I'll give you a sort of a flavour of why it is that I think that organisations are deterrable, and what I'm suggesting is that they have certain capacities that make them deterrable parties, and particularly when we move away from personal capitalism, when we move towards medium-sized and larger organisations. Okay, what I do in the paper is I hypothesise a vicarious liability judgment against an organisation, and the question is, what does the ideal organisation do by way of response? And can we see here the operation of a deterrable party? And I'm going to suggest that in many cases the answer is yes, organisations are deterrable, not necessarily that deterrence always happens. Okay, the first step is the receipt of a judgment, and I'll simply point to the fact that often there will be experts, lawyers available to interpret those judgments and to advise the organisation. In a vicarious liability case, there'll be typically no determination of fault. In the Gravel and Carroll case, the Court of Appeal, for what it was worth, did identify where they thought the fault in the defendant occurred, but that was not necessary to the reasoning. But if a vicarious liability judgment is significant enough, then the organisation might want to know what went wrong and conduct some kind of investigation. The business organisation literature will tell you that whenever there's an exogenous event, including, for instance, a judgment against an organisation, this is the start of a learning process. If anyone wants these PowerPoints afterwards, I'm happy to send them, but I'll just go through this a little bit speedily because I think you'll get the idea. Right, so there's several steps in which we might see deterrence occurring. Then there is the formulation of a response. And if we ask what organisations are all about, and organisations are about groups of persons who are brought together in order to achieve particular goals. So the very point about organisations is that they constrain and in fact direct behaviour, and they do this through a number of what we call integration mechanisms. Okay, there are all sorts of ways in which organisations do constrain behaviour. So just to summarise, through structures, specialisation of function, they've got their own internal rules, policies, processes. They might have multiple levels of supervision, reporting, training of employees, and also there are wider aspects of the culture which will infiltrate through to individuals. So writers on business organisations think that organisations are these regulative frameworks with embedded standards of interaction. And there's a sense in which perhaps the law can just plug into those organisational structures in order to help bring about change. And it's change that doesn't just affect one person, the organisation, but all those who work for it. And in fact, transformation might be even wider than that. If you look at the sorts of responses that can be taken by organisations in order to prevent wrongdoing occurring in the future. Sorry, this just goes into too much detail, but the headlines are sort of in bold there. There can be changes to organisational structure. One of the things about management is that management should always be considering what are the best structures for the organisation. How much decision making should be made centrally? How much should be made closer to the coalface, or where, let's say, accidents or wrongs might occur? Changes in rules and procedures. You have got an internal type of regulation going on here. There are rules, there are procedures, ways of doing things, and these can, of course, be changed as a response to tort judgments. Changes in personnel. This is something which we see mentioned in these child abuse cases. What can you do in order to prevent the wrong types of employee being hired? So I could go on quite a bit about that. Changes in monitoring and accountability. In cases involving physical processes, managers can often directly supervise. In cases which don't involve physical processes, you've got more sort of indirect means of monitoring and control. And this is an important one, right? So I might just focus upon this, and I'll be pretty quick after that. Changes in industry partnerships. Now, the modern company, especially the modern company which is involved in manufacturing, is often involved in a network. So it works with other companies and it enters into contractual relationships in order to have parts of the manufacturing and distribution process allocated to different companies. So there are business reasons for this kind of disaggregation, the use of networks. Of course, we also know that there might be less admirable reasons for entering into network relationships, such as escaping responsibilities that come with having your own employees, including those that arise in vicarious liability. What if vicarious liability rules are actually made to extend beyond employees? There are dangers in this, because it might mean that responsibility is shifted from where it should be. But perhaps the clever thing about recent cases in the United Kingdom is that there's an air of uncertainty about how far an employer might be made liable for the torts of independent contractors. The point about this is that the organisation may be in a position where it can actually impact upon how its network partners do things. And that is especially in cases where the organisation has industrial or market power. Okay, change can be affected within organisations where management decides that a particular response should be implemented through its exercise of managerial authority. And essentially what we're talking about here is the idea that decisions can be imposed upon the unwilling. And as I've indicated, even if you're talking about a big organisation with a lot of people who are unwilling, change might be effectively brought about. And then, of course, there are other points about change, including the fact of compliance processes. And this is where I think that we might be able to make some recommendations for reform in the future. It might not be enough that the courts say that, well, you're vicariously liable, you should go and think about your structures, your processes, etc. It may be that in the future there should be greater oversight of of change after it has occurred. Not in every case, but certainly in a very interesting case, the BP oil spill case decided by the Eastern District of Louisiana a few years ago. BP was put under a very detailed a program of reform, and reporting and compliance mechanisms have been put in place to ensure that those reforms are actually carried out. And that includes, for instance, quite detailed requirements about the board of directors and things that members of the board need to do. Okay, so that's a possible suggestion for how we might take this forward in the future. The second part of this study, another 5 years perhaps, I hope to involve a study of organisations to see whether these things actually occur, and if they don't, where the blockages are. Thank you very much.